Morning, everyone, and thank you for joining our session with our guest speaker, Professor Smita Narula from Pace University. I'm Aubin, and I'm delighted to say a few words about our program, which is funded by the European Commission through the H2020 and Marie Curie actions. So this month, our series will also feature another speaker, namely Professor Deepa Badrinarayana from Chapman University, and it will be on May 19th. Also, we will have on May the 13th, a joint conference with the University of Lyon 3 in France on the scales of governance of the energy transition. So it will be a hybrid event, and you can access the registration links of both events on our website, www.law.uh.edu/EENR, where you will also find the upcoming events in the series and the great host of our past sessions. Feel free to use the chat box for your questions. And from now on, I'll turn it over to Professor Gina Warren, a co-director of the EENR Center and our chair this morning. Can you hear me?
Right, I can. Here we go. Thank you. I was making sure I clicked. I have a couple people in the waiting room, so just let me get those admitted. Sorry, trying to maneuver too many things here. Okay, so I have everyone out of the waiting room at the moment. And so let me introduce you to today's speaker. So Professor Smita Narula, sorry, I have people coming in. I want to make sure they all get in. Okay. Is the Haub Distinguished Professor of International Law at the Elisabeth Haub School of Law at Pace University, co-director of the law school's Global Center for Environmental Legal Studies. She's also the author and co-editor of dozens of widely published cited human rights, food systems, environment, types of articles, and she has helped formulate policy and legal and community-led responses to a range of social justice and ecological issues worldwide. Professor Narula graduated with honors from everywhere she ever attended, Harvard Law, where she was the editor-in-chief of the Harvard Human Rights Journal, and also she has a BA and an MA with honors from Brown University. Today, we have the privilege of hosting her and learning more about her current research. Can a right to a healthy environment deliver climate justice? Thank you so much, Professor Narula, for joining us today. I will turn it over to you.
Good morning, good afternoon, good evening, everyone, depending on where you're logging in from. Thank you so much for that warm introduction, Gina, and my huge thanks to Aubin for organizing this wonderful series and for inviting me to take part. I'm going to start just by sharing my screen, as I have a PowerPoint, so hopefully that is visible to you all. I'm also really happy to see colleagues and friends in the participants, and I think my mom just joined the event as well. So so be kind. My mom is here. Thank you, Mom, for joining. I wanted to today I'm going to talk about whether a right to a healthy environment, recently, just in October, recognized by the UN Human Rights Council, can deliver climate justice. But before getting to that question, I'm going to talk about a significant climate injustice that's unfolding right now. And I'm going to talk about why I think it's important that our conversations about human rights and the environment, or human rights and climate change, that we frame those conversations using a climate justice lens. So to begin with the injustice that we are dealing with right now, as many of you no doubt already know, we are, there's a heat wave that's gripping South Asia right now, and it's no ordinary heat wave. In India, both March and April broke records for the hottest months ever in the northern and central parts of the country. Temperatures in the capital, New Delhi, which is where I was born and where my extended family lives, soared to 117 degrees Fahrenheit or 47 degrees Celsius just this past Saturday, making it one of the hottest places anywhere on the planet. It's so hot, in fact, that landfills are spontaneously bursting into fire, as is pictured on the right, sending local air quality to 10 times the levels that are considered safe. In Pakistan, temperatures on Sunday rose to 129 degrees or 49.5 degrees. And those are the hottest temperatures recorded in the Northern Hemisphere so far. Urban areas have been subjected to emergency power cuts of up to 8 hours per day. And the extreme heat illness is made even more difficult by the fact that much of the heat wave coincided with the holy month of Ramadan, where many Muslims in both India and Pakistan fast during daylight hours. As has been noted by meteorologist and climate journalist Eric Holthaus, the South Asia heat wave is the emergency phase of climate change. And the map that you're seeing here certainly points to that emergency. Note that the figures that are indicated are the land surface temperatures in this region, which is the skin temperature of the ground. Images captured by satellite last week revealed that some parts of northwestern India exceeded 60 degrees Celsius in land surface temperature. That's 140 degrees Fahrenheit. Dr. Chandni Singh, who's a lead author of the Intergovernmental Panel on Climate Change, asserts that the heat wave is testing the limits of human survivability, which means that at some stage, a combination of both the extreme heat and the humidity just simply makes it impossible for the human body's organs to function normally. The body simply cannot adapt to the heat by cooling itself. So what does this mean? This means that more than 1 billion people are currently at risk of heat-related illness in and across South Asia. It's also important to note that the intensity, the arrival time, and the duration also point to the fact that the current heat wave is unprecedented. It's unprecedented, but it's not unexpected. In fact, this is exactly what climate experts have predicted would happen, and it's having cascading impacts on human health and on human rights. The warning signs have largely been ignored, especially by high emitting countries. And we can start to ask the question why they're being ignored. And this is actually what a climate justice lens and conversation enables us to do. My own views on why, some of the reasons why they've been ignored and that we need to center more in the conversation is that we think of these impacts as happening elsewhere and to others and to people who are routinely marginalized both within the global north and across the global south in these conversations, namely people of color, low-income communities, indigenous peoples, and more. But it's also ignored because it's really difficult to reconcile what we actually need to do about the climate crisis with our prevailing economic systems and the myth of progress being tied to endless economic growth using resources that are finite on this planet. Beyond the heat-related illnesses and deaths, there's also problems across South Asia of water scarcity, of power outages, and crop loss in the region. And these impacts in turn are affecting South Asians' right to health, their right to water, their right to food, among other rights. The wheat crop in Punjab, which is a northwestern state known as India's breadbasket, has been particularly affected this season. And that's bad news for the global food supply, as countries were looking to India to make up for the shortfall for their wheat supply that's been caused by the war in Ukraine. I'll speak momentarily about the unequal burdens of climate change across the globe, but for now, I wanted to point out that the burdens and human rights impacts of this heat wave are not being felt equally across the region. And that's because different communities have different capacities to either manage the heat or to avoid circumstances that put them in harm's way. Outdoor workers, for example, face serious health risks and a loss of their livelihoods. So daily laborers, farmers, street vendors, rickshaw pullers, and the unhoused simply do not have the option of staying home to work. In fact, most Indians do not have the choice but to work in conditions that provide little protection against the heat. People with disabilities, older people, pregnant people, and small children are also at particular risk of health impacts. Many children in rural areas attend schools with tin roofs inside sheds, which are unbearable in the heat. Schools have shut down for the summer much earlier than usual, affecting children's right to education. People living in poverty or who are otherwise marginalized also don't have access to necessary cooling that's required to survive the debilitating heat. Only a fraction of Indians actually own and use air conditioning, but even that small fraction is putting an enormous burden and demand on electricity, leading to power outages. There are also then significant gender dimensions to the impact of the heat wave. Photos such as this one taken at a public pool in Lahore, Pakistan, abound online, showing what some are doing to stay cool. But notice that in this picture, as in many others you may find in the news or online, those who are able to cool off in public pools or other waters all appear to be boys and men. Other genders simply do not have the luxury of bathing or swimming in public. And Dalit community members, formerly known as untouchables, who sit at the bottom of India's caste system, are often prohibited from touching or accessing the same water sources as dominant castes for fear that the touch of the Dalit community member will be polluting. All of which is to say, heat does not affect everyone equally, or climate change does not affect everyone equally. And while we tend to focus on the number of fatalities, it's important to center the ways in which extreme weather affects the day-to-day quality of people's lives. And in this particular region, the quality of well over 1 billion people whose lives are locked in now for decades into increasing longer and more deadly heat waves. While heat waves are not the only kind of climate change related harms that we're concerned about, what I hope this example makes clear is 3 things. Huge swaths of the world's population are already living under a state of climate emergency. 2, the climate crisis is also a human rights crisis. And 3, those who are suffering the greatest harms have contributed the least to that crisis. This last point I just made has led many, including Dr. Janvi Singh, to point to the heat wave as an example of climate injustice, highlighting that the millions upon millions affected are not the ones who created the crisis. She and others have also been adding that it's time for the historic emitters of greenhouse gases, including the United States, to step up and address the loss and damage that is already taking place across the global South. So in this talk, I plan to explore both the potential and the challenges of using a right to a healthy environment, which was, as I said, recently recognized by the UN Human Rights Council as a tool to remedy climate injustices. I titled my talk, "Can a Right to a Healthy Environment Deliver Climate Justice?" But I'd like to further break that question down into 3 sub-questions, which will also form the outline for the rest of my talk. The first question I want us to help answer is, why is it important to use a climate justice lens? The second is, what is the relationship between human rights and climate change? And the third is, what is the potential and challenge of using a right to a healthy environment to remedy climate injustices? So let's start with why use a climate justice lens. So as many of you are likely aware, climate justice is a concept that's used to frame climate change as a moral, ethical, and political issue, and not just an environmental issue. And it does so by relating the effects of climate change to concepts of justice, particularly environmental and social justice, and by recognizing, as I've said, that those who are bearing the brunt of the climate crisis have done the least to contribute to the harms. As such, using a climate justice lens, first and foremost, allows us to make visible these unequal burdens and the unequal blames of the climate crisis. And there's a great deal of data that makes this unequal burden and unequal blame abundantly clear. What you're seeing is a graph that was produced in an excellent report issued last year by Oxfam International called Carbon Inequality. And what Oxfam did is that it looked at emissions between 1990 and 2015, which was a critical 25-year period in which humanity doubled the amount of carbon dioxide in the atmosphere. And what their data and studies revealed is that the richest 10% are responsible for almost half of total lifestyle consumption emissions, while the poorest 50% were responsible only for around 10% of total lifestyle consumption emissions. Moreover, the richest 1% of the world's population was responsible for more than twice as much carbon pollution as 3.1 billion people who made up the poorest half of humanity. Those are astonishing, shocking figures brought into sharp relief by this particular graph. But it's important to go also back, much further back than 1990 to 2015, and to also think about historic emissions. As we all know, we are, after all, locked in now to the consequences of emissions that occurred decades ago. Another way to think about this, I think, and I'm somebody who likes to use visual data to help bring these points home, is to look at a side-by-side comparison of where emissions are happening versus where the impacts will be felt. And these are, I sourced these from two separate sources. There's likely more up-to-date information on the per capita graph on the left side, but the point here is to make visible, using these shades, that those who are most responsible, shaded in darker red on the left-hand side, are not the ones who are most vulnerable to the impacts of climate change, as shown on the right-hand side, which assesses the coping capacity of countries to adapt to or deal with climate change, in particular extreme weather events, sea level rise, agricultural productivity loss, and other risks overall. The maps are almost an inverse of one another. The human rights impacts of climate change are similarly going to be and have already been felt most acutely by countries across the global south, but also importantly by marginalized communities both within the global north and the global south. I often say that the global north-south dynamic is not just an inter-country phenomenon, it's also an intra-country phenomenon. So who does this include? Well, it includes women, children, LGBTQ community members, older persons, indigenous peoples, rural communities, persons living in poverty, communities of color, national, ethnic, religious, or linguistic minorities, caste-affected communities, migrants, persons with disabilities, and those living in geographically vulnerable areas. And of course, as with so many environmental vulnerabilities, many individuals also experience these vulnerabilities along multiple axes, and therefore their risks become compounded in many ways. As legal scholar Carmen Gonzalez puts it, climate change is a paradigmatic example of distributive injustice. And she adds that climate change is also inextricably linked to broader social injustice, including an economic order that systematically exacerbates poverty and inequality while exceeding the limits of the planet's finite ecosystems. And that brings us to the second reason why I think it's useful to use a climate justice lens. It helps expand our focus from what specific countries are doing to mitigate or address climate-related harms for their own citizens to a broader focus on the systems that are causing both climate change and human rights harms, namely extractive economies that have fueled the expansion of wealth and the redistribution of wealth from the global south to the global north, or to communities, wealthy elite communities in both the global north and the global south. Why that becomes important is because it's impossible to disentangle the climate crisis from these systems or from historic injustices, specifically from colonialism, from racial capitalism, and other historic and contemporary injustices. Using a climate justice lens, I think, also helps to broaden our focus to a wider range of actors, not just what is X country doing for its citizens, but what are other high emitting countries doing to address loss and damage issues across the globe? What are private actors, fossil fuel companies in particular, doing to address the harms that they are causing? And that's valuable for, I think, moral, political, and ethical reasons in addition to legal reasons, but I think it's also valuable because it gives us a sense of interconnectedness. It's sort of this idea that what we do here and the carbon and other greenhouse gases that we emit here affects lives everywhere. And the actions that we fail to take here also has detrimental effect everywhere. It also brings together an interconnectedness between the past and the present. It's simply impossible to approach the climate crisis and the solutions with blinders on and absent historic, not just injustices, but we cannot simply reproduce what we have done in the past and expect to have different outcomes in the future. A third and final reason why I think it's useful to use a climate justice lens is because when we recognize that the current crisis is the result of oppressive, unjust, and unsustainable systems, we can drive at very different solutions that are much more transformative and that seek to dismantle those very same systems. In addition, by centering the voices of those who are on the front lines of the crisis, we also center different solutions, such as just transition and systems change, instead of promoting green growth or technological fixes that will continue to leave critical populations and increasingly vast swaths of the global population outside of the benefits of those fixes. In other words, how we frame the problem drives how we answer or provide solutions to that problem. So a justice framing is particularly valuable. I want to turn now to the second question, which is, what is the relationship between human rights and climate change? Well, here, to put it plainly and quite obviously, the climate crisis is a human rights crisis. Here's a sort of one figure that shows the kinds of harms that will be experienced. I won't go through it. It's familiar to anybody who's listening or will be watching. But it's important to note that this wide range of impacts that we're looking at has a profound impact on human rights, especially economic and social rights, which often get centered in these conversations, like the right to food, the right to water, the right to health, the right to housing, and even the right to self-determination. I began my talk talking about the unprecedented heat wave in South Asia, but we could easily have also talked about rising sea levels that are a threat, posing an existential threat to small island developing nations in the Pacific Ocean, for example, undermining their right to self-determination. Or we could have talked about the almost 4-year drought that is taking place in Eastern Africa, and that's threatening to plunge up to 20 million people into starvation and completely destroy an ancient nomadic way of life, affecting their right to culture. We could have talked about the deadly flooding in Bahia, Brazil last year. And we also could have looked much, much closer to home at the wildfires that are increasing with more intensity and frequency in the United States, or the flash floods right here in my own backyard in New York City and New Jersey last fall that killed dozens. Of course, many of those who died were low-income community members who were trapped in flooded basement apartments without an exit strategy, revealing, of course, that even in the global South, some communities are more affected by climate change than others. As has been said by others and very eloquently, we may all be in the same storm, but we are not all in the same boat. And then, of course, there are many who have less access to relief in the aftermath of crisis, which we saw both in the aftermath of Hurricane Maria, which wreaked havoc in Puerto Rico, pictured here, but also in the aftermath of Hurricane Katrina in New Orleans. Climate change and migration is another massive human rights concern. It's estimated that 20 million people per year are already displaced as a result of climate change. That's an average of 1 person every 2 seconds who's forced to migrate, leaving behind their homes, their sources of livelihood, and likely their cultural heritage. The impact on civil and political rights is less well considered, but it also happens when climate-related policies proceed without the meaningful involvement or consultation with affected communities. That's a violation of civil and political rights. Climate activists and land rights defenders who stand up to destructive industry practices are also increasingly subject to violent attacks, to sexual assaults, to slap suits, death threats, and more, and many are even killed. The most recent report by Global Witness, titled "The Last Line of Defense," revealed that 2020 was the highest year on record for the killings of land and environmental defenders, with 227 documented killings. Again, Indigenous peoples and communities in the global South were disproportionately affected. So alongside this recognition that climate change and the climate crisis is a human rights crisis, there's also growing recognition that states have specific human rights obligations when it comes to addressing these harms. And these obligations arise and are embedded in states' obligations when they ratify various international human rights treaties. It's now well understood and increasingly agreed upon that states have both substantive and procedural obligations when it comes to climate change. Substantively, states have to protect human rights from climate-related harms, and they have to pay particular attention to vulnerable groups. They also have human rights obligations to undertake both mitigation and adaptation measures, but also have to ensure that these measures don't contribute to more human rights harms, as can happen, for example, when conservation measures collide with the rights of Indigenous peoples when they take place on their territories. And they have an obligation of international cooperation, which is limited and which I'll come back to. And then there are procedural obligations. States have to ensure that the affected public is adequately informed, that they're involved in the decision-making around mitigation and adaptation policies, and that they have access to legal remedies when their rights are violated. And finally, states also have a duty to protect against the activities and harms of private actors such as fossil fuel companies, and they have to regulate those actors, which I'll also come back to. So all of this recognition has been sort of a part of what's been called the greening of human rights, which successive special rapporteurs on the right to a healthy environment, on human rights and the environment, rather, have been bringing into view, right? It's this idea that states have to do all of this because climate change has such an enormous impact on so many other rights, or the environmental degradation has an impact on so many other rights. It's impossible to enjoy the right to food, health, etc., without a clean, stable environment and without a climate system that facilitates the ability to enjoy those rights. And now we have another tool in this toolbox, right? In a major development in October, the UN Human Rights Council adopted a resolution recognizing for the very first time the right to a clean, healthy, and sustainable environment. I'll let you read for yourselves the language, some of the language of that resolution. And by the time you're done reading it, you may feel like, yeah, okay, that's not very exciting. It's recognizing a few things. There's what's really going to happen and what's going to change. You may also be thinking about the fact that international human rights law is really late to the party. More than 150 countries already recognize and protect the right to a healthy environment through their constitutions, national laws, and judiciaries, or ratification of regional and international instruments. Professor Jimmy May, who is on the Zoom with us, along with his colleague Aaron Daly, has actually meticulously looked at and brought into view the number of constitutions that protect the right to a healthy environment in some form or another, and both at the national and subnational level. But I would argue that even though this feels like words on paper, it's actually an incredibly meaningful turning point in international law. And it's meaningful for a few reasons. The first is because it is a profound expression of the lived realities of vast swaths of the global population that are demanding an alternative vision of progress, away from the idea of endless and destructive, abusive economic growth as the measure of progress, towards staking a claim for a right to a clean, healthy, and sustainable environment as a right that is inherent to us all just by virtue of being human and being born with dignity and rights. And as is often the case, what finally lands on paper under international law begins as a very profound call for social justice, and in this case, environmental justice, by social movements around the world. International law is an echo of a much stronger call. And as that echo, it does become a lot more muted by the time it gets to paper and by the time dozens of governments have approved its adoption, in this case still as soft law by the Human Rights Council. But it's also significant because if this moves forward, as we hope it will, to the General Assembly as a resolution, and if adopted there, it opens the door, it really breaks the door wide open to be able to read this right implicitly into binding international human rights treaties. This was exactly the same trajectory that was followed by the right to water and sanitation, which is not explicitly recognized in international human rights law, but through a General Assembly resolution is now part and parcel of the canon of international human rights law and deeply embedded also in the Sustainable Development Goals. So the hope is also that a right to a healthy environment and human rights law in general can be used to achieve climate justice. But as I'll argue for the remainder of my talk, there are both opportunities and challenges in using such a right to bring about this kind of justice. I'll start with the challenge. I argue that the right to a healthy environment is not in and of itself going to cure some of what I call the structural deficiencies of international human rights law. And there are two deficiencies in particular. The first is international human rights law's territorial limitations. As those of you who are familiar with this body of law know, states have concrete human rights obligations to their citizens. So not only are states, we are all rights holders, but states are duty bearers. But those obligations have largely been defined in territorial terms, meaning the government of India, to use the example from the beginning, is obligated to respect, protect, and ensure the human rights of the citizens and individuals within its territory or under its jurisdiction. Now, sometimes jurisdiction can expand to other categories, such as during wartime or under occupation, but it's largely a territorial scope of imagination of where governments have human rights obligations. That's really not going to, that deficiency is very problematic when you think about using the right to a healthy environment to ensure climate justice, precisely because the actions that governments or fossil fuel companies are taking in one region are, as we've already shown, deeply affecting the lives of communities across borders or extraterritorially. But international human rights law doesn't really have an answer to that question yet, though hopefully an answer is developing. To put this a different way, what good does it do to insist that the government of the small Pacific island nation of Vanuatu fulfill its human rights obligation to protect its own population from rising sea levels when it has neither caused the problem nor has sufficient resources to fix the problem? Human rights law's response to that question is to point to the obligation of international cooperation, which, as discussed previously, is quite limited because high carbon emitting states have so far refused to couch any of their aid giving actions or loss and damage actions in any kind of legal obligation terms. International cooperation is seen as part of being a member of a civilized sort of international community, and cooperating, including in the realm of international environmental law, which I'll come to address these concerns, but it has not been seen as a legal obligation, and certainly not with anything with the kind of teeth that's needed to ensure that countries address the extraterritorial impacts of the harms that they take place within their borders. Ultimately, and I think quite purposefully, human rights law was not created to challenge an unjust international economic order or today to address the extraterritorial impacts of climate change, and nor was it created to deliver systems change, and I'll come back to that. Another significant deficiency is human rights law's state-centric focus. All of these obligations that you see on your screen are obligations assigned to state actors specifically. And to date, hard legal obligations do not apply to non-state actors such as corporations, including fossil fuel companies. There is soft law. The Ruggie principles talk about both the state's duty to protect, but also corporations' duty to respect human rights, and for the states to be able to provide an effective remedy when rights are violated. But that's very different than being able to turn concretely to corporations to be able to say they have hard legal obligations. That too is seen as a significant structural deficiency of human rights law. And together, these collective deficiencies, I would argue, make it difficult to really point at the violator, address the victim, and be able to provide the remedy. In other words, international human rights law is not at the moment normatively equipped to address the interconnectedness of the climate crisis that I was talking about earlier, neither in the sense of historic wrongs versus present wrongs, but also in the sense of where the harm takes place and where the impact is felt. Having said that, there is also tremendous opportunity in using this new tool to deliver climate justice. I think first and foremost, the formal recognition of a right to a healthy environment under international human rights law provides a much needed bridge between international human rights law and international environmental law, which to date have largely developed along separate tracks. And the idea that these two fields must inform each other and governments' obligations under these two branches of international law must be read together is explicitly recognized in the UN Human Rights Council resolution. You'll see in number 3, it affirms that the promotion of the human right to a clean, healthy, and sustainable environment requires the full implementation of multilateral environmental agreements under the principles of international environmental law. I think the weaving together of these two branches is long overdue and is also being accomplished by this process that John Knox has called the greening of human rights, in which I spoke to earlier. But this sort of makeshift timeline that I created also shows us sort of where we are and why it's important to bring that together. In 1948, when the Universal Declaration of Human Rights was first promulgated and adopted, the word environment didn't appear anywhere in the document, and that makes sense. We were responding to the atrocities of the time, and the environment just wasn't front and center in the international community's mind. Come 1966, the ICCPR and ICSCR, which codified the rights contained in the UDHR, were adopted and then ratified by many countries, and together with the UDHR became the International Bill of Rights. And then in 1972, the Stockholm Declaration comes along, and with it, the rise of environmental constitutionalism and the birth of international environmental law. The Stockholm Declaration, many people will point out, does have a nod to a right to the healthy environment. But then it wasn't again until 2015 that the idea of human rights and the environment explicitly started to converge in the context of either in treaties and in soft law. The Sustainable Development Goals started to really understand the social equity dimensions of development, adding it as a pillar alongside economic and environmental pillars. And the Paris Agreement finally explicitly called on states to ensure human rights in the process of addressing climate change. That then brings us to the present time, which I'll come back to, but I'll just say with this Venn diagram that I also tried to create, there's an interesting, I think, convergence going on here. And I would put the right to a healthy environment sort of at the center of these two rights, if sets of laws. If international human rights law is aimed at ensuring the rights to life, health, housing, food, water, etc. On the one hand, international environmental law, states undertake obligations to regulate with a view to addressing climate change, ozone depletion, biodiversity loss, and more. The right to a healthy environment sort of comes in between, weaving these two together. And they've already started to be tied together by the recognition of Indigenous peoples' rights in both fields. And also they both share in common a strong understanding that procedural rights, such as ensuring access to information, participation, and justice when rights are violated, are going to further states' commitments under both international human rights law and international environmental law. But coming back to these, and these are some of the points I'll sort of spend the last few minutes on, I think it's incredibly important to understand where we are right now. We are right now in the present in a moment where advocates around the globe are increasingly using climate change litigation to compel more transformative, powerful climate change mitigation action by governments using governments' human rights obligations. And in this way, I see the right to a healthy environment potentially also helping to remedy deficiencies in both these areas. And I'll explain how. International environmental law, which is where many people focus for states' obligations to address climate change, does not give individuals standing to actually compel governments or bring suit to ensure that they're living up to their obligations under various multilateral environmental agreements, including the Paris Agreement. International human rights law does give individuals standing. And so what you're seeing is climate change advocates and activists using international human rights law to give them standing to bring greater action. This was seen perhaps most significantly and famously in the Urgenda, the Dutch case, Urgenda case, which in 2019, the Dutch Supreme Court held that the Dutch government, in line with its human rights obligations, must immediately reduce its greenhouse gas emissions. We can all agree that even those reductions were not drastic enough, but the point is that climate change advocates now have a footing and standing to bring action because of that ability under human rights law. In that case, it was under the European Convention on Human Rights. Similarly, I think international environmental law helps fill a deficiency in international human rights law. And specifically, I think it does so because it recognizes that the duty not to cause transboundary environmental harm under international environmental law is customary international law. And in fact, you know, the entire sort of architecture of the climate change regime has been built around this idea of avoiding transboundary impacts. When you put together customary international law, the transboundary norms, as was revealed and solidified in the Trail Smelter case, up against extraterritorial human rights obligations, I argue that what you're seeing is a normative convergence that's taking place between the two, and that advocates and litigators are taking advantage of. Already in some petitions, including a petition that was just before the Children's Rights Committee, you see using both states' obligations under the Children's Rights Convention combined with their obligation under multilateral environmental agreements and customary international norms not to cause transboundary environmental harm as the basis for a claim that was brought by 17 youths arguing that high emitting countries were not rising up to their obligations of ensuring the best interests of the child. Another way in which I think international environmental law helps to cure another structural deficiency of international human rights law is with the principle of common but differentiated responsibilities. And I think we all know that that's a principle that's infused throughout multilateral environmental agreements. And it's the basic idea that some states must take greater responsibility for climate harms than others, or for environmental harms more generally than others. And this principle didn't naturally come about in international environmental law, but it was a hard-fought concession by industrialized countries that their wealth and prosperity has come about as a result of great environmental and climate destruction, and as a result of harms done to former colonies. Although many would argue that these principles are still more sort of like paper tigers and they're more relevant on paper than they actually are in practice, they at least reflect an idea and concept of justice and interconnectedness and the need to address historic wrongs, which I would argue international human rights law does not do. This normative reckoning of a painful and unjust past and present is largely absent from international human rights law, which seemingly sort of just starts from scratch, asking all states to fulfill the rights of their citizens without looking at the ways in which they have been incapacitated historically to do so. So in the end, where we're coming at right now is a point, I think a very exciting point, where several things are happening. I think there is a normative shift of consciousness, even the ability to name the right to a healthy environment under international law. There's a converging of two fields that are using the strengths of each to fill in for the deficiencies of the other. And there is a very motivated litigant class all over the globe that's using human rights, and hopefully in the future can also use the right to under a healthy environment under international human rights law to compel states to take action. Coming back to our conversations of sort of who's responsible and who bears the burden, I find it particularly exciting the cases that are being brought to compel states to specifically to regulate fossil fuel companies that are under their jurisdiction, as was the case with another Dutch case in 2021, Milieu de Foncy et al. Versus Royal Dutch Shell. And we're going to see much more corporate accountability litigation come down the line. I think these cases are also most powerful and most profound when they're brought in high emitting countries by citizens whose actions and whose consumption lifestyles are affecting the global south. And we're seeing that happen in other countries, in many countries as well, not here in the United States, but in other high emitting countries. I think I would be remiss if I didn't conclude this talk by bringing attention to the fact that at the end of the day, law is but one tool that we have in our toolbox. And at a moment of such profound intersecting crises, at a moment of emergency, as I began the talk with, we simply cannot rely on any single tool, but it's an ever sharpening tool. It's a useful tool, but I think it's a tool that also needs to be used alongside social movements, alongside direct action, alongside profound and important demands for transformative systems change, so that we don't simply continue to replicate the climate injustices of the past, including with technocratic fixes whose impacts will also be borne by those who are already living in a state of emergency. I'll stop there with my thanks for this forum and the opportunity to share this project with you all. Thank you so much.
Excellent. Thank you so much. Okay, so what I would like to do, if it's okay with you, is if you would stop sharing, and then I'm going to, so Aubin, do you need to do a CLE slide or, okay, all right, so we're good. Okay, so what I would love to do is open it up to questions. And because we have some amazing people here that have been listening, I would love to hear their questions and see what, or comments. And so if you could you can just use the tool to raise your hand, and we will do that in that order. That would be fantastic. I know Professor May is here, Professor Koo, so I know that you guys probably have a lot of comments and thoughts to add to the discussion. All right, let me do this. Let me remove this. And then, okay, so Professor Koo, Katrina, do you want to, Kat? Let me try to, I'm trying to speak at the same time I'm trying to spotlight, and it's never easy for me to do that. So go ahead while I try to do this.
Well, thank you. Something that I will be thinking about for a while was your description of what you called the normative convergence between customary international law related to transboundary harm and extraterritoriality in human rights law. And something your approach made me think about that I honestly had not thought about at all until your presentation is, to what extent will bringing climate and climate justice and environment into human rights law change human rights law itself? And it makes me think of, and I wonder if that's maybe your next article, because you know me, I always see how can we use human rights law to help us deal with climate change. And it reminds me very much of the incredible work that Doug Kaiser has done thinking about that from a tort law perspective. So I'm curious if you thought about that at all, how engaging with international environmental law may change human rights law.
Thank you for that. And thanks so much for joining today. My thanks to all. I know it's the end of the semester and I'm so happy to see such incredible scholars and friends with us. I think it will, and I think it already is changing human rights law. And you can start to see that in opinions or an advisory opinion by the Inter-American Commission on Human Rights, by the general recommendations or comments by treaty bodies. We are sort of, many people, like you said, international environmental lawyers or environmental law, climate change folks generally are getting very excited about human rights law. It's sort of giving it another wind at a time when human rights law is also taking a beating in many other ways. And I think it's reifying and re-legitimizing human rights law in some ways, because environmental advocates see it as being able to have a concrete standing and tool to be able to address environmental harms. On the other side of that, as you point out, human rights law, I think, is also benefiting in that it is forcing the extraterritoriality conversation in a way that it really brings extraterritorial human rights harms into sharp relief in a way that I think no other issue has done so far, right? And environmentally, that's often been the case with other environmental concerns, but climate change in particular, given the capacity of emissions from one area to affect the entire ecosystem and the global atmosphere, really brings that into sharp relief. So I do think it's changing. Many people would also had to browbeat the human rights advocates for sort of waking up to the environmental issues and the harms because they took a long time to do it. Successive special rapporteurs played a huge role in that, as did folks like Philip Alston, who, when he was the special rapporteur on extreme poverty and human rights, put out this scathing report calling out his own human rights scholars and community for not paying sufficient attention to the environment, but also pointing out the risk of what he termed climate apartheid, of communities increasingly being able to, I think about the very few who are using air conditioning and power in India right now, put themselves into these smaller protected bubbles while the rest of humanity is, in this case, literally frying. So I think it affects both, and that might make it into this article as well. Thank you, Katie.
All right, Professor May.
Hi, Smita. Fantastic presentation. Your comparative work is just amazing. It's eye-opening, and it's incredibly depressing, right? Giving everything that's happening, like you say, the mirror image of that you had in one of the early slides about countries that are responsible and countries that bear the burden of climate change. But that's not where I'm coming from. My two questions, one goes to conscience and the other goes to conflict. I'm wondering if you could comment further on why do you think courts in particular have been so reluctant to embrace rights-based approaches to climate change. There are a couple of judges who have spoken out and using rights-based kind of language, like Judge Aiken in the Our Children's Trust case, and also Judge Staten from the Ninth Circuit was sitting by designation on appeal. But other than that, even in these climate cases all across the United States and across the globe, seldom do courts use the language of human rights. They do something like there are cases in Pakistan, in India, that cited in your work. But that's one thing. So I'm just wondering why the reluctance, do you think? Secondly, is about conflict. The human rights, it designates a field, not a particular outcome. So of course we've had the UDHR since 1948 and so on and so forth, but there's a human right to work, to education, to self-autonomy. And so you're not seeing this coming, but like what happened in Ohio in the elections with J.D. Vance winning the nod for the Republican Party in the Senate. He spoke a lot in terms of rights, but not the way we are. The right to work, the right to exploit, the right to self-development, and those kinds of rights. So that's a conflict between like a right to stable climate and healthy environment, and then
Uh-oh,
Did he freeze for everybody?
froze. He did. He froze just a little bit, but hopefully, I think we have the gist for, and so if you want to go ahead and
Sure.
answer.
So I think he's coming back. Okay.
Nice.
I'll start with the reluctance of why courts have been reluctant. And I think as Professor May, as Jimmy just said, it's not all courts, right? There are many courts that are actually at the national level have been extremely, Jimmy's back. All right, I'm going ahead and answering your question. Okay. So I think on the reluctance there, it depends on the region that you're talking about. And we're talking about national courts. And as Professor May said, there are courts like in South Asia, for example, India and Pakistan that have really embraced and have long embraced a rights-based approach. And then the United States, where it's sort of, it's really seen as anathema and pushed aside. I think Professor Q could give an entire lecture on climate litigation in the United States, among many other topics, including what that reluctance is. But I'm going to answer this question from a historic contextual point of view for international human rights law in the United States. So many people may know or may not know that the United States has long drawn very hard lines between economic, social, and cultural rights as non-rights, but as aspirations or something that, you know, people can sort of work around themselves, versus civil and political rights as what is a fundamental right, as is reflected in the in the US Constitution. And that division is seen through the history of international human rights law itself. The Universal Declaration of Human Rights was supposed to be codified in a single human rights treaty, but it was bifurcated into two, the Covenant on Civil and Political Rights and the Covenant on Economic, Social, and Cultural Rights, precisely because of the Cold War politics at the time, with the then Soviet Union arguing more heavily in favor of economic, social, and cultural rights, and the US decrying those as fundamental rights and saying that the real rights were civil and political rights. I share that, and the US has yet to ratify, has signed but has not ratified the Convention on Economic, Social, and Cultural Rights. The reason I bring that up in this context is because I think it's part of the culture of our constitutionalism to not see certain rights as real or fundamental rights, including being very scared to acknowledge rights where the justiciability of that right or the clarity of how it might be justiciable is not completely apparent or clear. That's at least how some people have explained the reticence to environmental rights in this country. But as others have pointed out, including a student of ours, Sean Hickson, has just written a terrific paper actually showing that the right to a healthy environment in the United States actually looks a lot more like our constitutional rights than the scary social and economic rights, because it also calls for procedural interests, governance, information availability, et cetera, participation to be protected. But Jimmy, so that's my answer is I think that's one of the reasons is it's a historic pushback. But I'm encouraged that many countries that in Europe are starting to embrace a more rights-based approach or being pushed to. I'll say just very briefly on the conflict that's embedded. I think some rights, I think if you start to look at international human rights law as a source, it becomes very clear, you know, what it considers fundamental rights versus what it doesn't. It's very easy to put the word right in front of something and use the language of rights also as a way to push back against the rights of others. And those conflicts exist in the international environmental and human rights realm as well. Many countries in the global south have historically, for example, argued against environmental regulation calling for their right to development as being impeded by having to follow sort of a non-industrial path when other high emitting countries had the luxury of doing so. And I think that's a really important point. And there's also conflicts that exist between having to, when states take mitigation and adaptation measures, which themselves can interfere with human rights. But I think the broader point and what climate justice movements to end there are bringing into view is that that conception of the right to development is actually going to be undermining for development and human rights and the environment at the end of the day, and that we have to really fundamentally critically inspect what we mean by sustainable development, to push beyond endless economic growth as the myth and measure of progress, and to think about transformative systems change where you don't have to, conflicts will always exist, but where you don't have to think of these issues sort of as a zero-sum game. What does a system that allows us to be connected and humane and allow people to live with dignity, both human and non-human life, and sustainably, what would that system look like? And that system, and we're very far from what that looks like. And I don't think international human rights law gets us there, but what it does get us to, and what this right does, is a shifting of consciousness of what to put first. And also it gives us yet another tool to compel those who have an unequal and disproportionate share of the blame to take more responsibility to support those who are facing the unequal burden.
Thank you. That was illuminating and edifying. Thanks so much.
Yes, brilliant.